Okay, let's unpack this. Picture this. You're at the top of your game, a high-flying corporate executive in a massive global company. Then, bam,
Hmm.
you're facing serious criminal charges.
Yeah, serious stuff.
You go to trial, and maybe against what you expected, you're convicted, sentenced. But you fight back.
You don't just accept it.
Right. You take your case through the appeals process. And in doing so, your very personal, high-stakes legal battle ends up fundamentally changing a rule about how evidence is handled, not just for you, but potentially for everyone in Australian courtrooms.
It's a pretty dramatic story, isn't it? And what's particularly fascinating is how two seemingly unrelated legal sagas, one focused on these alleged corporate falsifications, the other a massive regulatory fight against an international cartel, they kind of unexpectedly converged.
Converged how?
To create this really significant shift in Australian evidence law. It just goes to show you the law isn't some static rule book. It's constantly being tested and, refined in the crucible of real cases.
Absolutely. And that unexpected convergence is exactly what we're diving deep into today. Our focus is on two specific Australian legal cases. Gregg VR, which tells that executive's dramatic story, and ACCC v. Air New Zealand, not one, that big regulatory battle against the air cargo cartel.
Right.
Our mission is to trace Mr. Gregg's journey, understand the serious allegations he faced, see how his case moved through the courts, dissect the crucial legal arguments that ultimately overturned his conviction, and then reveal how his fight, combined with that separate ACCC action, led to a major change in how documents are treated in courtrooms across the country.
So think of this as a deep dive into, corporate intrigue, courtroom strategy, and the unpredictable ways legal principles evolve. For you, our listener, it's a chance to see how the rules that govern justice, even the really technical ones, are hammered out in the real world, with real stakes for the people involved.
Yeah, and it gives us a window into the immense complexity of corporate conduct and the challenges the legal system faces trying to grapple with it all. Right. So where does this all begin? Our story is set in the high-pressure world of Leighton Holdings Limited, or LHL, back around 2011. This is a massive Australian holding company, a giant in construction and mining.
Huge. Subsidiaries everywhere.
Exactly, spread out across the globe. Two key pieces of this empire for our story were its international arm, Leighton International Limited, LIL, and a joint venture they had established in India known as Leighton Wellspun Contractors Private Limited, or just Leighton Wellspun.
Okay, got it. And at this specific time, 2011, LHL was navigating some serious financial turbulence. The company was facing significant challenges, most notably an expected loss of AUD $427 million for the financial year.
Wow, $427 million loss.
Yeah, a dramatic and, unwelcome shift from their earlier profit forecasts.
Yeah.
Naturally, this put an intense focus right at the top of the company on cost efficiency, improving performance, that sort of thing.
Makes sense.
The CEO at the time, Mr. David Stewart, was reportedly keen to move away from the previous model, independent operating companies, and find ways to leverage the sheer size of the group for better efficiency across the board.
And within this pressured environment was the India joint venture. LIL had entered into this venture with the Indian-based Wellspun Group, which was controlled by Mr. B.K. Goenka.
Right. And as part of setting up that relationship, LIL had sold a 35% stake in Leighton Wellspun to Wellspun Infer Projects Private Limited, which was part of Mr. Goenka's group. And it was this transaction that had some rather critical and potentially costly financial terms attached.
Okay, so what were these terms?
Precisely. One key term was what was called the held back amount. This was roughly AUD $8 million, or about 40 crore Indian rupees, that was held in escrow. The deal was this money would only be released from escrow and paid to Wellspun Infer if Leighton Wellspun hit a specific financial target.
A performance target.
Yeah, an EBITDA target of approximately AUD $68 million, or 340 crore, by June 30, 2011. If the target wasn't met, Wellspun Infra would get that AUD $8 million back.
Okay, so money conditional on performance. Standard M&A stuff, sounds like. But the flip side of not hitting that target was where things got potentially very expensive for Leighton, right?
Exactly. This is where the infusion obligation comes in, and it looms large in the background of this story. If that EBITDA target was not met, and Wellspun Infra consequently got their held back amount back,
Which was looking likely.
reportedly yes. Then, under the terms of the term sheet agreement, LAL had a binding obligation to infuse up to INR 100 crores into Leighton Wellspun. At the time, that was roughly equivalent to US $22 million or AUD $20 million.
US $22 million. That's a substantial sum, especially when the parent company is already facing hundreds of millions in losses.
A huge sum.
And infusing money to the Indian joint venture sounds straightforward, but you mentioned there were difficulties with this obligation.
There were significant concerns within LHL about this potential obligation. Not only was it a large amount of capital to deploy, but there were real worries about getting money out of India. Tax and regulatory issues meant that funds infused into the joint venture could potentially be tied up in India for years, difficult or even impossible to repatriate back to Australia.
Right, a major headache.
This was a significant potential financial hit for LHL at a time they desperately needed liquidity and efficiency. The Wellspun side, including Mr. B.K. Goenka, was reportedly keen to find a resolution to this potential obligation, with discussions happening about potential waivers or, alternative structures.
So you have this backdrop, a global construction giant under immense financial pressure, a looming, potentially crippling financial obligation tied up in India from a joint venture, and top-level pressure to find efficiencies and resolve financial headaches. This is the highly charged environment.
Exactly, the perfect storm, almost.
In which the allegations against Mr. Peter Gregg, who was the chief financial officer of LHL during this period, would take shape.
Precisely. As the CFO, Mr. Gregg was squarely in the sights of the regulators investigating these matters. He was charged with offenses contrary to Section 13071 of the Corporations Act 2001, that's Commonwealth legislation, which criminalizes the falsification of company books.
Falsifying company books. So what did they actually accuse him of doing?
The prosecution alleged he was responsible for conduct that led to false entries in LHL's records, specifically concerning two distinct events that occurred relatively close together in late 2011.
And these two events were central to the Crown's case, weren't they?
Absolutely. Let's break them down. The first was Count 1, which focused on a specific payment instruction issued on August 15th, 2011. Now, here's where the timing becomes immediately critical.
Okay.
According to the sources and evidence, this instruction came just 2 days after Wellspun Infra had formally waived that crucial INR 100 crore infusion obligation on August 13th.
2 days. Wow. Okay, that timing coincidence certainly grabbed your attention. What was the nature of this instruction?
It was a handwritten instruction from Mr. Gregg himself, directed to Mr. Thomas McKay, who was LHL's Executive General Manager of Treasury. It was quite specific, directing two payments to be made today, Monday, U.S. time, to an account for a company identified as Asian Global.
Asian Global, okay.
The instruction detailed the purpose of these payments. U.S. $12.5 million for marketing advisor services and a further U.S. $2.5 million described as a loan at the prevailing USD rate for 12 months. The total sum directed was U.S. $15 million.
So U.S. $15 million heading out the door to Asian Global, described as payment for services and a loan. Where did the Crown allege the falsification lay here?
The Crown's core allegation for Count 1 was that the stated purposes written on this payment instruction were simply false.
Just made up.
They argued these descriptions, marketing and advisory services and loan, were a complete fabrication, a smokescreen designed to hide the real reason for sending that U.S. $15 million.
And the real reason, according to the Crown?
Well, the strong implication the Crown pushed, though it was a circumstantial case, was that this true purpose was somehow connected to securing that vital waiver of the infusion obligation from Wellspun, which had just occurred 2 days prior. The drama for the prosecution was all in that timing and the alleged hidden motive behind the stated purpose.
So the payment instruction itself was the company book, and put of a false purpose down was the falsification. What about the second count? This involved a different document.
Yes, Count 2 revolved around a document described as a buy and sell agreement. This agreement was physically executed around December 19th, 2011, several months after the payment instruction.
Okay, months later.
However, and this is another key piece of the Crown's case, the agreement was dated August 1st, 2011.
August 1st, but signed in December.
Exactly. This backdating placed it before the August 13th waiver and before the August 15th payment instruction.
Backdating a document like that certainly looks suspicious on the surface. What were the terms of this agreement dated August 1st?
The agreement was between LHL, called the buyer, and Asian Global, called the seller. It set out commitments from Asian Global, including giving Leighton Orders preferential status for delivery through its contacts and ensuring faster-than-market supply timeframes.
Sounds like procurement advantages.
In return for these commitments, LHL, the buyer, would pay USD $15 million on execution of this agreement. Critically, the consideration was explicitly stated as being not refundable and non-adjustable against actual orders placed.
U.S. $15 million for potentially securing better procurement terms, things like faster delivery. And that's the same U.S. $15 million amount from the payment instruction in August.
Exactly. The numbers lined up. The Crown's core allegation for count 2 was that this buy and sell agreement was not a genuine commercial contract, but a sham agreement.
A sham, meaning
Their argument was that neither party, LHL nor Asian Global, ever truly intended for this agreement to have any real legal effect or commercial consequences. Instead, the Crown alleged it was created later, in December, but backdated to August, simply to provide a fabricated, official-looking justification or cover for the U.S. $15 million payment that had already gone out in August.
like reverse engineering a reason for the payment?
Pretty much. The idea of a backdated fake contract to provide a smokescreen for a large payment is certainly a central piece of the corporate drama here.
So the two counts are tightly linked in the Crown's theory. An alleged false purpose on a payment instruction potentially covered up later by an alleged sham backdated contract. It all centers on the idea that the official records didn't reflect the true nature of the transaction.
That's right. And like any good drama, you need a cast of characters to understand how this unfolded. The court documents lay out the key players in this story, revealing a complex web of relationships and internal dynamics within Leighton and with their partners.
Okay, let's run through the main players, the dramatis persona. At the very center, the main character, is Mr. Peter Allen Gregg, the appellant, the former CFO of LHL, facing these serious charges and fighting for his reputation.
We also have Mr. Thomas McKay, the Executive General Manager of Treasury for LHL, who was the direct recipient of Mr. Gregg's handwritten payment instruction on August 15th. He was the one tasked with making those payments.
On the other side of the payment and the buy-sell agreement was Asian Global. The key individual representing Asian Global who signed the buy and sell agreement was Mr. Mahesh Khemka.
And tied into the whole backdrop of the infusion obligation and the waiver is the Wellspun Group, controlled by Mr. B.K. Goenka. The waiver of the INR 100 crore obligation came from Wellspun Infra, part of Mr. Goenka's group.
Right, the Indian partner.
And importantly, the court records highlight that both Mr. Goenka and Mr. Khemka were not called as witnesses by the Crown during the trial. As we'll see, that became a significant point later on.
Interesting. Okay, who else? Other figures within Leighton play supporting roles, providing crucial context and evidence about the corporate environment and events.
Yeah, there was Miss Amita Chatterjee involved in executing agreements like the term sheet for LIL and Leighton Wellspun.
And Mr. Russell Wong.
Another Leighton executive who communicated with Mr. Gregg and Mr. Goenka regarding the infusion obligation waiver. He was also an uncalled witness at the trial. Mr. Parvez Umragar was likewise involved in related discussions about the infusion and also wasn't called to give evidence.
Several uncalled witnesses who seem quite relevant to the waiver part of the story.
Exactly. The Crown's decision not to call these individuals, who were seemingly central to the waiver discussions, was questioned later.
And then there's a whole collection of other Leighton executives and personnel whose evidence painted a picture of the company's challenges and internal politics at the time.
Right. Mr. David Stewart, the CEO who Mr. Gregg would eventually replace, described his desire to move away from independent operating companies towards a more efficient group structure.
But his testimony also revealed some friction.
Significant friction with Mr. Gregg, apparently. He saw Gregg as a strategy guy, but apparently disliked his management style and reportedly wanted to get rid of him.
Wow, okay. Not a supportive boss, then.
Doesn't sound like it. And Mr. William Wild, the deputy CEO, also reportedly shared this sentiment towards Mr. Gregg. With his extensive engineering background, he was initially skeptical about centralizing procurement across Leighton's diverse operations, but acknowledged the company was moving towards leveraging its scale.
Mr. Peter Kent, another executive involved in a project reviewing the business, was aware of the infusion issue and the shift towards strategic procurement. He reportedly gave the U.S. $15 million payment only cursory consideration initially.
Yeah, believing it wasn't connected to the Australian entity, apparently.
And Mr. Stefan Sass, involved in reviewing offshore businesses, echoed the sentiment that Mr. Gregg views himself as a strategic leader but didn't collaborate effectively, and stated he and Mr. Stewart wanted to remove him.
This internal tension at the top of LHL is definitely part of the backdrop. It adds another layer, doesn't it? Then there's Mr. Dan Cluett, the group accountant. He received the buy and sell agreement and, importantly for the prosecution, noted that Mr. Gregg contacted the accounting department on the day the agreement was signed.
On the day it was signed in December.
Yes, to ensure the U.S. $15 million payment associated with it was treated as an asset, written down over time rather than an immediate expense. The Crown suggested this showed Mr. Gregg knew the payment needed a justification beyond a simple expense.
Okay, that's potentially significant. What about the auditors?
Dr. Dieter Brixel, LHL's head of internal audit, raised serious red flags about the buy and sell agreement. He felt it wasn't commercially sound and expressed concerns to Mr. Gregg and another executive, Mr. Tyrwhitt. He even reportedly spoke to the chairman, Mr. Johns, about a perceived conflict of interest because he reported to Mr. Gregg as CFO.
A conflict for an internal auditor, that's not ideal.
Although Mr. Johns later testified, the auditor reported to the audit committee he chaired, not directly to Gregg in that capacity, but Brixel was clearly concerned.
Hey, Mr. David Johns, the chairman.
He confirmed the reporting line of the internal auditor to the audit committee. His evidence was also useful for the defense, though, as he stated his belief that marketing services payments could be consistent with global procurement initiatives being explored at LHL. So he provided some cover for that explanation.
Interesting. And the external auditors?
Mr. Ian Young, the KPMG auditor for LHL, provided evidence confirming his understanding of the potential infusion requirement and that Wellspin had advised in August 2011 that this obligation would be waived. His testimony helped establish the timeline around the crucial waiver.
Right, confirming that key date.
Yeah.
What about executives from the operating companies?
Mr. Greg Monroe, a former managing director of Thies, a major Leighton subsidiary, described the historical competitive structure of operating companies and later integration efforts. He mentioned Thies had a central procurement manager but had no knowledge of Asian, global, or sourcing steel through them, evidence the Crown used to argue the buy-sell agreement lacked plausibility.
So someone running a major subsidiary hadn't heard of this supposedly important supplier.
Correct. But conversely, Mr. David White, who was appointed asset procurement manager for LHL, testified that Mr. Gregg did champion strategic procurement and discuss potential cost savings, including steel, with him.
Contradicting Monroe's point a bit.
And critically for the defense, Mr. White confirmed he continued high-level discussions with Mr. B.K. Goenka about potential steel procurement opportunities after December 2011, and that he attempted to contact Mr. Kemka of Asian Global after the agreement was signed. This evidence directly challenged the Crown's idea that the buy-sell agreement led to no follow-up.
Okay, so evidence cutting both ways there. Anyone else significant?
Mr. Stephen Pack, involved in an LHL cost efficiency review, confirmed the review was in early stages, and while not specifically focused on steel savings, internal documents did discuss leveraging the holding company for purchasing efficiencies and exploring group-wide arrangements. This provided context for the defense's strategic procurement argument. And Mr. David Tyrwhitt was the executive Dr. Brixel spoke to about his concerns regarding the buy-sell agreement and who agreed internal approval was needed. He was another uncalled witness.
Lots of players. And finally, at the appeal stage, we need to mention the judges and the legal teams.
Yes, the appeal was heard by the NSW Court of Criminal Appeal. Bathurst CJ, Hoban CJ at CL, and Leeming JA. And the legal teams who argued the appeal were crucial. For the appellant, Mr. Gregg, it was Mr. T. Game SC leading Mr. J. Roy as counsel, instructed by Webb Henderson solicitors.
And for the Crown?
For the respondent, the Crown, it was Mr. T. McDonnell SC leading Mr. M. England as counsel, instructed by the Commonwealth Director of Public Prosecutions. Their arguments would be pivotal.
It's quite the list, isn't it? Each person playing a specific part in the unfolding of this complex corporate and legal drama.
It absolutely is. And seeing all these players helps understand the environment in which Mr. Gregg's case progressed. Let's trace that journey through the legal system now.
So the story starts with the charges being laid against Mr. Gregg. That implies a prior investigation, which would have involved regulatory bodies like ACCC, presumably looking into the financial dealings at Leighton.
Yes, though the sources don't detail the investigation itself, it's the necessary prelude. Following that investigation, Mr. Gregg was formally charged with the 2 counts under the Corporations Act, one for the August payment instruction, one for the December buy and sell agreement.
The case then went to trial before a jury. This took place in the District Court of New South Wales, presided over by Judge Lakatos DCJ. This was the main event, really.
It was. The trial was where all the evidence we've just discussed was presented. The documents, the payment instruction, the agreement, the testimony from all those Leighton executives, the arguments from the prosecution and the defense teams.
And what were the core arguments at trial?
At trial, the Crown presented its circumstantial case, arguing that the confluence of factors, the timing of the payment right after the waiver, the alleged lack of commercial reality for Asian global services, the backdated agreement matching the payment amount, the internal friction regarding Gregg all pointed, they said, unequivocally to the conclusion that the records were false and the agreement a sham, likely linked to resolving the infusion obligation issue.
And the defense?
The defense naturally presented their counter-narrative. They argued the transactions were legitimate, perhaps tied to a genuine attempt to resolve the infusion issue through a commercial arrangement, or consistent with the company's strategic shift towards group procurement, and that the backdating was just a formalization of an earlier understanding, not a fabrication. They challenged the idea it was a sham or that the payment purpose was false.
After hearing all the evidence and arguments and receiving directions on the law from the judge, the jury delivered its verdict.
And they convicted Mr. Gregg on both counts.
A tough outcome for him. What happened next? Sentencing.
That led to the sentencing hearing. Judge Leighton imposed concurrent terms of imprisonment, 12 months for count 1 and 2 years for count 2. However, the sentence was ordered to be served by way of an intensive correction order, or ICO.
An ICO, so not full-time custody.
Right. It's a community-based sentence, involves strict conditions, supervision, maybe community service, but not jail time. Still, a criminal conviction and a significant sentence.
So convicted and sentenced, but Mr. Gregg didn't accept the outcome.
Not at all. He sought leave to appeal against both his conviction and his sentence to the NSW Court of Criminal Appeal. This is a crucial stage in the process.
Where the higher court reviews the trial.
Exactly. They look to see if any errors of law or process occurred that led to a miscarriage of justice, or if the verdict itself was unreasonable based on the evidence presented at trial. His grounds of appeal were numerous, challenging the strength of the evidence, the judge's decisions on what evidence to admit or exclude, the instructions given to the jury, and the conduct of the prosecutor. A full frontal attack on the conviction.
The appeal hearing took place over 3 days in April 2020 before Chief Justice Bathurst, Justice Hoban, and Justice Leeming. This is where Mr. Gregg's counsel, Mr. Gamessi and Mr. Roy, instructed by Webb Henderson, argued passionately for his acquittal, dissecting the trial proceedings.
And the Crown, represented by Mr. McDonald SC and Mr. England from the CDPP, defended the conviction, arguing the trial was fair and the verdict sound.
And then the wait for the judgment.
And then, on September 30, 2020, came the decision. The NSW Court of Criminal Appeal delivered its judgment. They allowed the appeal. They quashed the verdicts of guilty on both counts.
Quashed them completely.
Completely. And most significantly, they entered verdicts of acquittal on each count. This means they concluded that, based on the evidence and the errors they identified in the trial process, no reasonable jury, properly instructed, could have been satisfied of Mr. Gregg's guilt beyond reasonable doubt. After years of legal battle, he was ultimately cleared of the charges. A total vindication on appeal.
Wow. From conviction and sentence to complete acquittal. That's a huge turnaround. What's fascinating here is unpacking why the appeal court overturned the convictions. Let's dive into the key legal battlegrounds where this case was won and lost at the appellate level.
Okay. The primary ground that led to the acquittal was the argument that the jury's verdicts were unreasonable or could not be supported by the evidence. This is known as the M test, essentially.
The unreasonable verdict ground, how does that work?
It's a rigorous test where the appeal court essentially puts itself in the shoes of the jury, reviews all the evidence that was before the jury, and asks if it was reasonably open to them to find guilt beyond reasonable doubt. It's a high bar for an appellant to clear.
And the court looked at this separately for each count. Let's start with count 2, the buy and sell agreement alleged to be a sham. What was the issue there?
Right. The Crown's case for sham was entirely circumstantial, as we discussed. They pointed to things like the agreement's seemingly uncommercial terms for LHL paying $15 hours up front, non-refundable, the fact it was backdated from December to August, and the apparent lack of concrete results or follow-up you might expect from a genuine procurement agreement.
Like Mr. Monroe from FI's not knowing about it, or no actual orders flowing from Asian Global.
Exactly. Or the defense pointing to Mr. White's attempts to follow up, or the strategic procurement context. They had counter-explanations.
So how did the appeal court weigh these competing interpretations? What was the fatal flaw in the Crown's case on the sham agreement?
This raises an important question about proving a sham agreement in law. The court highlighted a fundamental requirement that the Crown failed to meet beyond reasonable doubt.
Which was?
To prove an agreement is a sham, you generally have to show that both parties to the agreement subjectively intended for it to have no legal effect at all. And not only that they had this secret intention, but that each party was aware of the other party's intention for it to be a sham.
So you need proof of a shared understanding that it was all just for show, and that both sides knew the other person was in on it. Like a secret nod and wink between them.
Exactly. Think about it. If one side genuinely believed it was a real contract, maybe LHL thought they were getting strategic services, even if Asian Global was secretly just pocketing the money with no intention to deliver, it's very difficult to say it was a joint deception, a true sham in the legal sense. You need that shared fraudulent intent.
Right. It takes two to tango on a sham.
Precisely. And the court found there was a critical lack of evidence, particularly from the Asian Global side. Key individuals like Mr. Kemka, who signed the agreement, and Mr. Goenka of Wellspun, whose group was connected to Asian Global and the infusion issue, were not called by the Crown to give evidence about their subjective intentions regarding this agreement.
The uncalled witnesses again.
Yes. Without direct evidence from them, or other incredibly compelling circumstantial evidence about their intent, the court concluded it was simply not possible for the jury to be satisfied beyond reasonable doubt that Asian Global and LHL both intended for the agreement to be a sham, and that each knew the other's intention. The evidence just wasn't there to prove that shared state of mind to the criminal standard.
That makes perfect sense. You can't prove a joint deception if you don't have sufficient evidence about the intent of both parties involved. A major gap in the Crown case.
A fatal gap, the court found. And the court's finding on count 2 had a direct knock-on effect for count 1, the allegation that the payment instruction was false.
How so?
Well, if the buy and sell agreement wasn't proven to be a sham, then the Crown's main argument for why the U.S. $15 million payment instruction was false, that it was really payment for the waiver, not the stated services loan, was significantly undermined.
Because the defense could argue the payment was genuinely related to the agreement, which hadn't been proven fake.
Precisely. While the Crown speculated the payment was for the waiver, the defense presented a plausible alternative hypothesis that the parties, Gregg for LHL and potentially Asian Global Wellspun, had agreed to enter into an arrangement like the buy and sell agreement and the loan component as a way to resolve or substitute the potentially onerous infusion obligation. It might have been an unusual deal, maybe even a bad deal for LHL in hindsight, but not necessarily a false one in terms of the description on the payment slip.
And there was evidence supporting this alternative.
Yes. Evidence from witnesses like Mr. Johns supporting the plausibility of marketing and advisory services in a strategic procurement context, Mr. White's evidence about ongoing discussions, and even evidence of draft loan documents for the U.S. $2.5 million component supported this defense hypothesis. It was a reasonable possibility on the evidence.
And the court found the Crown hadn't disproven this alternative explanation beyond reasonable doubt.
Exactly. The court found that the Crown had not excluded this reasonable hypothesis beyond reasonable doubt. Given this, it was not open to the jury to find that the stated purposes on the payment instruction entries were false, or that Mr. Gregg had acted recklessly in making them. So, the lack of proof regarding the sham agreement on count 2 flowed through and fatally weakened the Crown's case on the false payment instruction in count 1.
So, on the core evidence, the appeal court found the prosecution simply hadn't met the high standard of proof required in criminal cases. That was enough for the acquittal.
That's the fundamental reason for the acquittal on appeal, the unreasonable verdict ground. However, the court also went on to identify significant miscarriages of justice during the trial itself, highlighting crucial lessons for the conduct of complex criminal cases, even though they didn't strictly need to rely on these points, given the verdict finding.
Okay, so other problems with the trial. The first major area of miscarriage of justice related to the prosecutor's closing address to the jury. The appeal court was quite pointed in its criticism here.
They were. One significant issue was the prosecutor's repeated and extensive use of rhetorical questions throughout their address to the jury. Questions like, why isn't there evidence of X? What is the plan here? What does that suggest to you? Or pointed questions implying the Crown's interpretation was the only rational one.
Why is that a problem? Don't lawyers ask rhetorical questions all the time?
They do in advocacy. But in a prosecutor's closing address, especially in a complex circumstantial case where the accused hasn't given evidence, excessive rhetorical questions can be highly problematic. They can subtly, or not so subtly, shift the burden of proof.
How does it shift the burden?
Instead of simply stating the Crown's case based on the evidence they presented, these questions implicitly challenge the defense to provide answers or explanations for aspects of the evidence or lack thereof. They invite the jury to draw adverse inferences from the absence of evidence or explanation from the defense side. This can make it feel like the defense has to prove something, when in a criminal trial, the onus is always 100% solely on the Crown to prove guilt.
Right. It puts the defense on the back foot unfairly. And adding to that, the prosecutor also repeatedly pointed out that there was no evidence to support aspects of the defense case.
Right.
Or alternative explanations put forward by the defense.
Exactly. And as the court noted, this was particularly unfair given that the Crown itself had chosen not to call key witnesses like Mr. Gawinka or Mr. Kemka, whose evidence might have shed light on alternative explanations or the other party's perspective.
So the Crown is saying no evidence when they didn't call the people who might have provided it.
Precisely. Repeatedly saying no evidence from the defense side, when the Crown hadn't even called all potentially relevant witnesses, was seen as unfairly highlighting perceived gaps in the defense's presentation, rather than focusing solely on whether the Crown had positively proven its own case beyond reasonable doubt.
And the most serious complaint was the suggestion the prosecutor improperly commented on Mr. Gregg's failure to give evidence himself, which is strictly forbidden in a criminal trial. He didn't testify, right?
Correct. Mr. Gregg exercised his right to silence. And yes, commenting on that is a major no-no. While the prosecutor made some attempts to qualify these comments, stating they weren't commenting on the accused's right to silence, but on the state of the evidence generally, the court found these qualifications were insufficient and, in some instances, actually aggravated the problem.
So the overall effect.
The court concluded that the prosecutor's closing address, taken as a whole, was unbalanced, unfair, and, to a significant extent, reversed the onus of proof. That is strong judicial language. It serves as a powerful reminder that a prosecutor's role is not just to secure a conviction, but to ensure a fair trial. And this includes a scrupulous adherence to the principle that the onus of proof rests solely with the prosecution.
A significant rebuke. The second major area of miscarriage of justice, highlighted by the appeal court, related to the trial judge's directions to the jury on the law. Directing a jury in a complex case like this, with intricate financial details and a purely circumstantial case, must be incredibly difficult.
It is one of the hardest jobs for a trial judge, and the court found multiple errors in the judge's directions here. One significant issue involved the question trail provided to the jury.
A question trail, like a decision tree.
Sort of. It's a structured series of yes-no questions designed to guide the jury through the evidence and the elements of the offense towards a verdict. They can be helpful, but they have to be drafted very carefully.
And this one wasn't.
The court found that the specific way these questions were phrased, combined with an instruction that if the jury was undecided on a question they should answer no, which would lead towards acquittal on that path, effectively diminished the Crown's onus. It subtly risked placing a positive burden on the appellant, Mr. Gregg, to persuade the jury to answer no to certain questions, rather than the burden remaining squarely on the Crown to prove yes beyond reasonable doubt for each element of the offense.
So even the structure of the questions the jury had to answer could confuse them about who had to prove what. That's quite subtle.
Precisely. It's a very technical point, but one that goes to the heart of procedural fairness and the burden of proof. Another critical error was in the direction given on circumstantial evidence.
What was wrong there?
In criminal cases based solely on circumstantial evidence, the law requires that the Crown must not only show that the conclusion of guilt is a reasonable one, but must also exclude all other reasonable hypotheses that are inconsistent with guilt. It's called the rule in Hodge or Shepard.
The Crown has to disprove any other reasonable explanation.
Beyond reasonable doubt, yes. The trial judge's direction, however, essentially told the jury something slightly different. It implied that if the Crown's conclusion of guilt was reasonable, they should then consider if any other reasonable conclusion existed. This was fundamentally the wrong approach. The onus is on the Crown to disprove or exclude those alternative reasonable hypotheses, not for the defense or the jury to simply find one exists. It flips the burden.
Okay, I see the difference. That's a crucial distinction.
It's fundamental. This misdirection on the standard of proof for a circumstantial case was deemed a material error by the appeal court.
The appeal court also touched on other alleged errors in directions, such as the precise legal definition of false in the context of backdating documents and the definition of sham, particularly whether parties needed to be aware of the other party's intention for it to be a sham.
Yes, although the written direction on sham was largely considered correct by the appeal court, confirming that shared intent was required, they noted the oral summaries might have caused confusion. But the errors in the question trail and the circumstantial evidence direction were particularly stark illustrations of the challenges trial judges face in complex fraud cases and the high standard required to ensure a fair process.
So, these findings regarding both the prosecutor's conduct and the jury directions provide critical guidance for future complex criminal trials, reinforcing the need for meticulous attention to the rules governing fairness and the burden of proof.
Absolutely. Real lessons learned there.
So, Mr. Gregg is acquitted on appeal because the evidence wasn't strong enough to prove guilt beyond reasonable doubt, and significant errors occurred during the trial regarding fairness and jury directions. But as we teased at the start, this case became a vehicle for a much broader change in Australian evidence law, linking up with that completely separate ACCC case. This is where the legal principles side of the deep dive gets really interesting.
It truly does. This is the Rusu revolution bit. For a long time, Australian courts, particularly in New South Wales, had followed a principle derived from a 1999 case called National Australia Bank Ltd v. Rusu.
Rusu. Okay, what was the principle?
The principle, broadly stated, was that a document could not authenticate itself, meaning you generally needed extrinsic evidence from outside the document itself to prove that the document was genuine, that it was what it purported to be.
So if you wanted to use an email or a company report as evidence, you couldn't just point to the email itself and say, look, here it is. You often needed someone to testify, yes, I received this email, or yes, this report came from our company's files, or maybe even evidence about the computer system it came from.
Exactly. You needed something else to vouch for the document. This requirement for external proof, even for relatively routine documents whose authenticity wasn't genuinely contested, could make litigation, particularly large cases with many documents, quite laborious and expensive. Think about proving hundreds of emails.
Yeah, sounds like a huge hassle.
Yeah.
And this is where the ACCC v. Air New Zealand one case enters the picture, years before Gregg's appeal.
Yes. Back in 2012, Justice Perham in the federal court was presiding over the ACCC's massive prosecution of numerous international airlines for allegedly operating an air cargo cartel, essentially fixing prices for various surcharges on freight.
Right, that big cartel case.
The ACCC needed to tender a vast quantity of documents, emails, internal notes, meeting minutes, records from various airlines across the globe to prove the cartel existed. Proving the authenticity of every single one using the old Rusu approach would have been a monumental, maybe impossible task.
So Justice Perham took a fresh look at the Rusu principle.
He did, specifically in light of the Evidence Act 1995, which governs evidence in federal courts and is mirrored by equivalent legislation in many Australian states, including the NSW Act.
And what did he find?
He conducted a critical examination of the Rusu principle, paying close attention to Section 58 of the Commonwealth Evidence Act. The equivalent section in NSW is 183. This section essentially says that in deciding whether to admit a document or use it to prove a fact, a court can draw any reasonable inference from its form or content.
Any reasonable inference from the document itself?
Yes. Justice Perham reasoned that this section meant a court could infer a document's authenticity simply by looking at the document itself, its appearance, its contents, the letterhead, the email metadata, the general context. Does it look like a real email? Does it read like one? He concluded that Rusu's restrictive approach was inconsistent with the plain words of the Evidence Act.
And he didn't mince words about Rusu.
Not at all. He famously stated that Rusu, to the extent it states the authenticity of a document, could not be proved by consideration of the form or content of the document, was plainly wrong.
Plainly wrong. Strong words from the bench. So the federal court had already signaled a shift away from Rusu. But Gregg VR made it official in New South Wales.
That's right. It cemented the change. In Mr. Gregg's trial, his defense team, led by Mr. Gamis C., wanted to tender a document. Remember that global business overview presentation prepared by LHL's consultants?
Yeah, the one about strategic procurement ideas.
They argued this document was relevant because it showed that ideas like strategic or centralized procurement were being discussed within LHL, providing context and supporting the plausibility of the buy-sell agreement being related to such initiatives, not just a cover for the waiver payment. The trial judge, following the established Rusu principle in NSW at the time, refused to admit the document.
Why?
He said its authenticity hadn't been proved by extrinsic evidence, and its contents might be considered hearsay if used to prove those strategies were actually viable rather than just discussed.
And on appeal, Gregg's legal team seized on Justice Perram's reasoning from the ACCC case.
Absolutely. Counsel for Mr. Gregg argued strenuously that the trial judge was wrong to reject the document. He argued it was admissible not to prove the truth of anything stated in the document, like whether central procurement would work, but for the non-hearsay purpose of showing that these strategic ideas were simply being discussed within LHL at the relevant time. That was relevant to Gregg's state of mind and the context.
Crucially, they attacked Rusu directly.
Yes, they directly challenged the reliance on Rusu, citing Justice Perram's decision in ACCC v. New Zealand and pointing to the equivalent Section 183 of the NSW Evidence Act. They basically said, the federal court says Rusu is wrong, the act supports that, NSW should follow suit.
This is where the two cases converged. The ACCC case provided the ammunition, and the Gregg appeal provided the NSW battleground.
This is the pivotal moment. The NSW Court of Criminal Appeal, led by Chief Justice Bathurst, took this opportunity to address the discrepancy and provide a definitive ruling for New South Wales. Chief Justice Bathurst explicitly reviewed Justice Perram's reasoning in the ACCC v. New Zealand case regarding Section 58(1), the equivalent of NSW's Section 183.
And what did Bathurst CJ conclude?
He found Justice Perram's reasoning compelling and unreservedly adopted it. He didn't just agree. He stated unequivocally that Rusu, to the extent it states the authenticity of a document could not be proved by consideration of the form or content of the document, was incorrectly decided.
Incorrectly decided. That's big.
Huge. Justices Hoban and Leighton J fully concurred, agreeing that Rusu should now be regarded as bad in law on this specific point. The court confirmed that Section 183 of the NSW Evidence Act does allow courts to draw reasonable inferences about a document's authenticity from its form, content, and provenance where it came from, like being produced from a party's business records and discovery.
Yeah.
You don't necessarily need someone to get in the witness box just to say, yes, that's the email I sent.
Wow. So a long-standing principle that documents generally couldn't authenticate themselves is now officially overturned, thanks to the combined force of an ACCC cartel case and a corporate fraud appeal. Amazing convergence.
That's the Rusu revolution driven by these two cases, and it has quite significant practical implications for litigation in Australia, particularly in the uniform evidence law jurisdictions like NSW, Victoria, the Commonwealth, and others.
What are those practical implications for lawyers and courts day to day?
The most immediate is the streamlining of evidence presentation. Lawyers no longer face the automatic hurdle of needing extensive, extrinsic evidence witnesses, affidavits about document handling, just to get routine documents admitted whose authenticity isn't genuinely in doubt.
So it's easier to get documents like emails, reports, meeting minutes into evidence.
Potentially, yes. They can rely on the document itself and the context it comes from, its provenance, to argue for its authenticity under Section 183. The court can look at it and say, yeah, that looks like a genuine business email from that company's server, and admit it, unless the other side raises a specific, credible reason to doubt its authenticity.
That sounds like a massive efficiency gain, especially in big cases.
It has the potential for substantial savings in litigation time and costs. Think of a large commercial dispute or a regulatory case like the ACCC cartel case involving thousands or even millions of documents. Avoiding the need for laborious formal proof procedures for documents where there's no real dispute about whether they're the actual email or report they appear to be can free up court time and reduce legal bills significantly.
It shifts the focus.
Exactly. It shifts the focus from sometimes pointless formal authentication hoops to the real issues. Whether there's a genuine reason to doubt the document's authenticity or what weight should be given to it, or whether its contents are admissible for their truth.
So Mr. Gregg's fight for acquittal ended up facilitating a change that makes the court system potentially more efficient for everyone handling documentary evidence. That's an incredible, perhaps unintended legacy of his case.
It is indeed a personal legal battle becoming the vehicle for broader legal reform. Fascinating how law develops sometimes.
Beyond overturning Rusu, what other broader lessons can we draw from the Gregg VR case, especially regarding complex trials? You mentioned the issues with the trial itself.
Several key points stand out, I think. The case really underscored the immense difficulty trial judges face in complex criminal trials, particularly those involving circumstantial evidence and intricate financial matters, when it comes to crafting accurate, balanced, and comprehensible directions for a jury. It's just so hard to get right.
The multiple errors identified in the jury directions on the definition of terms, the burden of proof, handling circumstantial evidence, and even the structure of the question trail highlight just how crucial and challenging this task is, and the need for extreme precision from the bench to avoid miscarriages of justice.
Absolutely. The critique of the question trail in this case is particularly relevant for practitioners and judges who use or are considering using similar structured aids for juries. It shows that even well-intentioned tools can inadvertently affect fundamental legal principles if not crafted meticulously. You have to be so careful.
The case also offered a strong reminder about the high standards expected of prosecutors, didn't it?
Yes, definitely. The appeal court's pointed criticism of the prosecutor's closing addressed the overuse of rhetorical questions, commenting on no evidence and implicitly touching on the failure to give evidence serves as a powerful reinforcement of the prosecutor's obligation to maintain fairness and impartiality. Their job isn't just to win.
Right, is to present the case fairly.
Exactly. It demonstrates how, even with attempts to correct course, advocacy can cross the line and unfairly prejudice the accused, especially in complex cases where the lines might feel blurry. It's a real warning shot for prosecutorial conduct.
And the discussion around uncalled witnesses, what's the lesson there?
While not the decisive factor for the acquittal on the evidence ground, the issue of the Crown's decision not to call key witnesses like Mr. Goenka, Mr. Kemka, Mr. Waugh, Mr. Umrigar, and Mr. Tyrwhitt was noted by the court, particularly in the context of the prosecutor's no evidence comments. It implicitly reinforces the importance for both sides, but perhaps especially the Crown with its resources, to carefully consider the implications of not presenting evidence from individuals who appear central to the facts in dispute. It can create inferences or weaken arguments down the track.
And finally, it reaffirmed a core principle about circumstantial evidence.
Correct. Gregg VR provided a clear and necessary restatement that in a criminal case relying purely on circumstantial evidence, the Crown's burden is not just to show their interpretation leading to guilt is reasonable. They must go further and exclude all other reasonable hypotheses that are inconsistent with the accused's innocence beyond reasonable doubt. The trial judge's failure to properly explain this fundamental principle was a material error. It's a bedrock principle.
Turning briefly back to the ACCC v. Air New Zealand case, beyond its impact on the Rusu principle, it was a major piece of litigation in its own right, wasn't it?
Oh, absolutely. It was a landmark case for the ACCC. The cartel proceedings ultimately resulted in total penalties amounting to AUD $132.5 million being ordered against 15 international airlines, including Air New Zealand, Garuda, Qantas, Singapore Airlines, and Cathay Pacific. It was a massive undertaking.
Huge penalties.
Yes, involving significant legal teams from major firms like Gilbert plus Tobin for the ACCC and others like Allens, Clayton Utz, Minder Ellison representing the airlines. It really demonstrated the ACCC's determination and global reach in pursuing anti-competitive conduct, even complex international arrangements if it impacts Australian markets.
And Justice Prem's decision there also clarified some other useful points about documentary evidence in the digital age.
Yes. He also provided helpful guidance on the definition of a business under the Evidence Act, confirming it can include nonprofit undertakings like industry associations. And he confirmed that electronic documents like emails and their attachments, even if just briefly stored by a law firm during discovery, can qualify as business records, making them potentially admissible under those provisions of the Act. These points are very practical for commercial and regulatory litigation today, where so much evidence is electronic.
So both cases, each arising from very different circumstances, corporate fraud allegations and an international cartel bust, ended up contributing significantly to clarifying how our courts handle modern, often digitally based documentary evidence.
They are definitely key reference points now in evidence law discussions. Two quite different paths leading to important clarifications.
And that brings us to the end of this deep dive. We followed the dramatic personal and legal saga of Mr. Peter Gregg, from the executive suite of a corporate giant, through criminal charges, a jury conviction, and ultimately, a hard-fought acquittal on appeal. We've seen how his case exposed the immense complexities and challenges of conducting complex criminal trials.
And we've seen how this particular case, driven by an appeal argument regarding the admissibility of a document, combined with the needs of a massive regulatory case like the ACCC's air cargo cartel prosecution against Air New Zealand and others, converged in an unexpected way to overturn a long-standing principle of evidence law, the Rusu principle, paving the way for potentially more efficient handling of documents in courtrooms across Australia.
Why does this story matter to you, the listener? because it illustrates in vivid detail that the principles of justice and the rules that govern our courts are not static. They are living, breathing things, constantly being tested, debated, and refined in the crucible of real cases involving real people and high stakes.
It also highlights the inherent difficulties in proving subjective intentions, what was really going on in someone's head within the complex, often opaque world of high-level corporate finance and international transactions. Proving a sham requires getting inside minds, which is incredibly hard.
Definitely.
And it underscores the absolutely non-negotiable importance of procedural fairness, accurate legal directions to those deciding guilt or innocence, the jury, and appropriate conduct from all parties, especially the prosecution, within the justice system, particularly when someone's liberty and reputation hang in the balance.
This journey, from a boardroom facing financial woes, to a court battling over alleged false documents, to an appeal court setting new precedent on evidence, shows how individual stories can truly drive systemic change within the legal landscape.
It's a powerful reminder of that interconnection.
So here is a provocative thought for you to consider as we wrap up. In a world where we are drowning in digital documents, emails, instant messages, contracts stored in the cloud, endless data trails, how will courts continue to navigate the tension between the need for efficiency in admitting this vast quantity of evidence, like the change prompted by Gregg and ACCC, and the absolutely fundamental requirement to be truly sure of its authenticity and what it really means?
That's a huge challenge, balancing speed and certainty.
And what does the struggle to prove the actual purpose behind complex financial arrangements, as we saw in this case with the payment and the agreement, tell us about the ongoing challenges of holding corporations and executives accountable in our increasingly globalized and digital era? How do we really know what the deal was?
Points well worth pondering. The search for truth and complexity.
We hope you found this deep dive insightful.
Until next time.